Can both teams please turn on their cameras and unmute themselves? Okay. Team 23, are you there?
Sure, I want to be looking at yourself. Put yourself on. This way you are smiling.
Yes, yes. I'm going now to column 3. Thank you.
Thank you.
Clark?
Sir? Yes, sir. Where's Team 23? Team 23, can you please turn on your camera and unmute yourself? It seems we are holding on for Team 23. They're yet to join us.
I think you can call it because they are the defense, then we can try to sort their issue out.
Oh, okay, sir. Okay. Since all the judges are now present. All rise. The African Court of Justice and Human Rights is now in session. President Catherine and the Honorable Judges, Judge Marvelous and Judge Aishat presiding. The case before the court is the situation in Mapalo's engine. The parties are the Office of the Prosecutor versus the Defense at Gabolo. The prosecution and the defense are each allowed 35 minutes to present their pleadings.
So can the prosecution please proceed?
Most grateful, Your Excellency. May it please this honorable court. Before it at in FIM 2022-15, our humble appearance for the prosecution. Before this honorable court is a case verging on its admissibility, the grounds of believing the existence of war crimes and the corporation of criminal responsibilities at Gabulu, following its position in the True Liberation Army a terrorist organization. It is the presumption of the prosecution that the facts of this case is before this honorable court. In a bid not to waste the time of the court, we shall commence our arguments. We seek the leave of this court to adopt our filed and dated on the 10th of April before it. The prosecution shall be serving 5 minutes for rebuttal. I will be engaging the court on the first and second issue for 20 minutes, while my co-counsel will engage the court on the third issue and say our prayers for the period of 10 minutes. In the prayer that the pretrial chamber confirms the charges brought before it, we shall be contending on the first issue that this case is admissible before this court. On this, we shall argue that there are reasonable grounds to believe war crimes occurred in the territory of Zengin. And on the third issue, we shall contend that Adu Gabolo can be held criminally responsible as a commander based on the facts presented before this court. We seek the leave of this court to proceed with our arguments. The first issue distinct for determination borders on the questions the admissibility of this case in this court. In contending that this case is very much admissible before the African Court of Justice and Human Rights, our arguments shall be focused on two aspects. The first being that this court
I don't know if I'm the only one that lost her.
Yeah,
Right.
she's gone. The network is.
I mean, let's give her like 2 minutes if she can reconnect.
Yeah.
Madam President, maybe we can have P2 proceed with the arguments that he's supposed to handle. Then when she comes back, we can from her.
Yes, absolutely. Absolutely. So please, prosecutor, to proceed.
Most grateful, Your Excellency. Your Excellency, on the third issue, which borders on whether the facts presented are capable of justifying the criminal incorporation of responsibility on the defendants, whilst it is the contention of the prosecution that these facts are indeed justifying this incorporation, it is very important to reproduce the provision of 3 of the Malabo Protocol, of which this issue substance. Your Excellency, this article reads that the fact that any of the acts referred to in Article 28A of the present statute was committed by a subordinate does not, Your Excellency, does not relieve his or her superior of criminal responsibility if he or she knew or had reasons to know that the subordinate was about to commit such crime. Your Excellency, flowing from this, it is very apparent that the literal and explicit interpretation of this statute is premised on the fact that the physical presence of such superior is immaterial in vesting the criminal responsibility on the defendant. Your Excellencies, the articles that have been referred to in Article 28 they include war crimes, and war crimes have been categorized to be physical harm, mental harm, rape and sexual violence, kidnap, attacks on buildings, and amongst others. This has equally been corroborated by Article 7 of the Rome Statute of the International Criminal Court. Your Excellencies, clearly the True Liberation Army has violated every categorization of war crimes as I have posited. Your Excellencies, in paragraph 4, it is recorded that they killed soldiers and children. In paragraph 5, it is recorded that they attacked and raped the Fulani women for all intent and purposes. In paragraph 6, it's equally recorded. Yes,
what
Excellency.
age under international humanitarian law is a children? What age, or between what ages is a children under international humanitarian law?
Between 0 to 14, Your Excellencies. Your Excellencies.
I didn't understand. Can you repeat your answer, please?
0 to 14 years, Your Excellencies.
Thank you.
Yes, Your Excellencies, in the argument of justifying the incorporation of responsibility on the defendant, we shall be arguing this under 2 heads, which is leadership and incitement. Your Excellencies, on the argument head of leadership, going by the clear provision of paragraph 8 of the Moot Pact, it is clearly established that the defendant is an unofficial leader in the True Liberation Army. More particularly, Article 12 of the True Liberation Statute confirms that and extends his power to the military operations in the True Liberation Army. Noteworthy is the fact that the defendant was indeed serving as the Minister of Defense in Chuma. However, Your Excellencies, it is the position of the prosecution that this service in no way limited or incapacitated the defendant in performing his responsibilities and exercising his powers as vested in Article 12 of the True Liberation Movement, of the True Liberation Statute. Your Excellencies, it is the further submission of counsel that the defendant had the command responsibility in relation with Article 46B sub 3, which provides for criminal responsibilities for superiors. Your Excellencies, in the case of prosecution,
let me interrupt you
yes?
again. Can you provide this court with any case law in which immunities have been waived in a criminal proceeding before an international criminal court?
Yes, Your Excellencies, this has been clearly established in the case of prosecutor versus Gaddafi. Besides, it is a cardinal principle of international law that immunity is not in question. However, this shall be treated in further arguments as regards in contrast with the Malabo Protocol. Your Excellencies, in the case of prosecutor versus Delalik, in paragraph 605, the court enumerated in the regard of command responsibility that there must be an effective control test, in which the court further enumerated them to be in 2. The first, Your Excellency, is that the accused had power to give orders. The Moot Pact has clearly established that Abu Gabolo is an unofficial leader in the True Liberation Army. Article 12 of the True Liberation Movement Statute further vests powers on him with regards to the military operations of the True Liberation Army. This can also be said, in other words, to be that he had the powers to give orders with respect to the military operations in the True Liberation Army. The second element as provided for in the court, in the case of prosecutor versus Delalik, is that the order must have been carried out. Your Excellency, it's clearly established that the attack, the rape, and the abduction on the Fulani women were carried out based on the instruction of the defendant in question, Your Excellency. This further, in conclusion, means that the defendant in question is in fulfillment of the two elements as provided for in the case of prosecutor versus Delali, which provides for, Your Excellency.
Can you kindly direct the court to the exact facts that shows that Adugo Bolo had given instructions to the CAOA?
Yes, Your Excellency. In one of the evidence that have been adduced before this honorable court, which is the seasoned non-governmental organization report, it is recorded that in a letter that was written from Kefudino, a commander in the True Liberation Army, to Adugo Bolo, it is recorded that an advice was given to Kefudino to attack and rape and give the Fulani women to the young wolves of the True Liberation Army. And this attack was carried out. This, in other words, is that an order was given to Kefudino and the order was carried out, which has been clearly established in the Moot fact. Consequently, Your Excellencies, following the defender's position in the True Liberation Army and the fact that he had criminal command responsibility, it is clearly established that he had
I lost him. Did you lose him as well?
Yes.
Okay. And is prosecutor 1 in the room? No. Clerk, is prosecutor 1 in the room?
May I confirm if I'm visible and audible before this court?
I'm sorry, we lost you in your connection. You were answering Mrs. Marvelous question. So maybe if you can go back to that point you were answering, please.
Yes, Your Excellencies. I posited, it is the position of the prosecution that the order was given out and carried out, which is clearly established in one of the evidence that has been filed before this honorable court, which is the seasoned non-governmental organization report. Your Excellencies, in this report, it was recorded that an order was given to Kefudino, who is the commander in the True Liberation Army, and that order was executed, which resulted in the attack and the abduction and the rape of the Fulani women, and they gave the Fulani women to the young wolves of the True Liberation Army. Consequently, Your Excellencies, based on the fact that the defendant in question has a leadership position in the True Liberation Army, and the fact that he had command responsibility, it is submitted that he had reasons to know, based on his leadership position, that the crimes have been committed or were about to be committed. Your Excellencies, on the second argument here, which is incitement. Incitement has been
before you move on, another question. You mentioned these reports, and
yes,
throughout the whole case, it mentions several NGO reports and other reports. Can you provide this court with any case law in which reports have been used as evidence before an international criminal tribunal?
Most grateful, Your Excellencies. Your Excellencies, in the case of prosecutor versus Ramabaku at the International Criminal Tribunal of Rwanda, may I confirm if I'm audible and visible before this court?
Can continue.
Yes, you are.
Yes, you can be heard.
Yes, please.
Most grateful. In the case of the prosecutor versus Ramabaku, it was recorded by the International Criminal Tribunal Court of Rwanda, where the court posited and ruled that a chamber has the power and discretion to admit hearsay evidence in form of news reports, in form of reports from news and reports from NGOs, and that even when the source cannot be corroborated, the tribunal still has the power to admit such into evidence. This has all equally been given a judicial recognition in the case of Jawara versus Gambia, where the court stated that it would be damaging to the administration of justice if the court disregards the reports of news and the reports of non-governmental organization reports following the fact that they play a major role in war crimes and before the International Criminal Court. May I confirm if I'm audible?
Yes.
Most grateful, Your Excellencies. On the second standpoint of argument, which is incitement, incitement has been defined as the act of persuading others to commit a crime. Your Excellencies, in enumerating for what constitutes the mode of responsibility, it has been enumerated in Article 28N of the Malabo Protocol, which reads that an offense is committed in this statute for any offense, which includes war crimes, where a person in paragraph I is recorded incites, instigates, directs, organizes, finances, counsels other person or acts as a principal in the commission of any of these offenses. Your Excellency, the Moot Pact has clearly established that the defendant is in violation of this provision as he has incited, instigated, and counseled others to join the True Liberation Army in their nefarious activities. Your Excellencies, in paragraph 9 of the Moot Pact, it is recorded where in a conversation between the defendant and the student comrade, where the defendant stated and advised other people to join the True Liberation Army in making a few more targets on the Malabo people, a few well-targeted cruelty on the Malabo people. Your Excellencies, this statement does not only adhere to the fact that it supports the evil actions of the True Liberation Army, it is also evident that he's inciting more people to join these people, as his goal is for the Malabo people to lose their democratic nature. Further, Your Excellencies, it is indispensable to bring to the notice of this honorable court of a report that has been adduced before this court, which is the Seasoned Non-Governmental Organizations, where it is recorded that the defendant in question advised Kefudinho, and the advice was carried on, which led to the attack of the Funani women and the rape of the Funani women in this instance. Further, Your Excellencies, is worthy of note that the international investigations and the Zengin prosecutions all led to one conclusion, which is the fact that the defendant in question is the chief strategist in the shooting down of a defenseless aircraft that was encompassing 200 civilians that lost their lives. Your Excellencies, premised on this fact, on his position of leadership, on the fact that he had command responsibility in the True Liberation Army, on the fact that he has incited more people to join the True Liberation Army in executing their evil actions, and on the further fact of offense that he went ahead to seek for investment, for funds in the promotion of the nefarious activities of the True Liberation Army, which is in contravention of Article 2 sub 1 paragraph B of the 1999 International Convention for the Suppression of Terrorism. It is the submission of the prosecution that following these grounds, that the facts presented indeed justify the incorporation of responsibility on the defendant.
I lost him again. Is Prosecutor 1 in the room? Counselor, we lost you again.
I was praying before this honorable court that on the grounds that he had the command responsibility, his position of leadership, and the fact that he incited people, and on the further grounds that he went ahead to seek for investment in the promotion of the True Liberation Army, a terrorist organization, which is in contravention of Article 2, Sub 1, Paragraph B of the 1999 International Convention for the Suppression of Terrorism, it is the prayer of the prosecution to hold that the presented facts before this honorable court are indeed capable of justifying the criminal responsibility on the defendant. At this juncture, I seek the leave of this honorable court to defer proceedings to my co-counsel in taking issue 1 and issue 2 before I now take the prayers.
But Counselor, I have another question. And I believe that there has been already a national criminal proceeding against Mr. Bolo. So that's if we judge and we consider this proceeding, aren't we violating the non bis in idem principle?
Most obliged, Your Excellencies. Your Excellencies, the non bis in idem principle states that where a court has tried the defendant, the case cannot be further brought before this honorable court. However, it is the position of the prosecution that this particular case, was conducted in a mistrial. Your Excellencies, it is the position of the prosecution that this case was supposed to have been conducted in the court of Zengin, based on the fact that the crimes were committed in Zengin. Your Excellencies, in the case of prosecutor versus Charles Taylor, the court clearly stated that based on the fact that his crimes were committed in Sierra Leone, he was to be tried in Sierra Leone. Now, this was a defendant who was a president of Liberia. So, premised on this fact, Your Excellencies, and based on the decision of the court in prosecutor versus Charles Taylor, it is very evident that he should have been tried in the court of Zengin, and now that is when the principle of non bis in idem will be invoked. However, we cannot invoke the principle of non bis in idem on a proceeding that was done with a fault ab initio, Your Excellencies.
Thank you, Counselor.
Your Excellencies, it is my prayer before this honorable court, and I wish that this honorable court may indulge that in the absence of my co-counsel, I pray this honorable court will pause the time for the prosecution and give the defense their time, pending the time my co-counsel would be available, who is currently experiencing technical issues.
Thank you, Counselor. Clerk, is prosecutor 1 in the room? Or the defense team? Are they on? Because I think they are connected, but I'm not even seeing them or listening to them.
Defense team.
Your Excellencies, if I may I confirm from the clerk of the House with your indulgence on how much time the prosecution has left?
Can you talk, or can you talk with prosecutor 1 and see if she's able to connect?
Yes, I'll definitely do that, Your Excellency. However, may I know the time that's left for the prosecution to make arguments before this court?
Okay. And is the defense team connected?
I can see that they are around, but I think probably maybe also their network is not stable. Team 23.
if she answers you, prosecutor 2, if she answers you, we're waiting for her. Otherwise, I don't know, Mr. Suale, if we will join then judge's room and just score prosecutor 2.
Yes, I think you can be able to.
I think P1 is back.
Prosecutor 1?
Yes, Your Honor. Yes, Your Excellency.
Okay, yes, I see you now. So yes, if you want to start over, so we
Yes,
can.
Your Excellency.
Thank you. And can you please talk a little louder, please? I'm not listening you. I'm not listening to you quite well.
Okay. Can I confirm if Your Excellency can hear me?
I'm sorry. Can you repeat?
Can I confirm if Your Excellency can hear me clearly now?
Yes, perfect.
Most grateful, Your Excellency. The first issue questions the admissibility of this case. It contending that this case is very much admissible before the African Court of Justice and Human Rights. Our argument shall be focused on two aspects. The first is, and the second aspect of our argument will be focused on the fact that this case does not fall within the grounds of inadmissibility of a case before this court. It is necessary to look into the jurisdiction of this honorable court, as it is only a court that has jurisdiction to hear a case that can look into the issue of admissibility of such case. Especially the first aspect of our argument, which is the exercise of jurisdiction of this honorable court. The foundation the Court of Justice and Human Rights, hereinafter known as the court, and the Malabo Protocol. Article 28 on the protocol of the statute of this court provides for the court rules of jurisdiction and gives power to this court to sit and adjudicate on cases having to do with the interpretation, application, and validity of treaties of the African Union. Article 6A bis of the Malabar the word consent is described as a simple note of the jurisdiction of any international court, not in the case of the Michelas versus Senegal. It can be inferred from this statutory authority that the country of Zengi gives consent to this court to adjudicate on this case.
I lost her. Did you all lose her as well?
I lost her too.
It is my prayer before this court that the defense carry on with the argument pending the time she's able to substantially recover from the technical issues that she's experiencing.
Mr. Suale, what should we do? We should just judge and score prosecutor 2?
Yeah, probably, because I'm also on the call right now with the defense team, and for them, they are saying on their end the network is fine, but from our end, we see all of us that the network is not fine. So I'm trying to sort it out for them.
But someone just joined the room. We lost you. We lost you again.
I'm sorry, Excellency. The rain after you is really giving me network issues.
No, don't worry. So maybe you can pick up like Is that and we weren't understanding you correctly, like you were going through your speech. So yeah, if you can just pick it up where you left, like where you left.
Okay, I was arguing the jurisdiction. I was arguing on the aspect of jurisdiction of this honorable court. Article 46A bis of the Malta Protocol provides that this court can exercise jurisdiction once a state has already ratified the protocol, once it has become a party to this protocol. Also, what it has established its consent by a court established consent, a state established consent by ratifying the Malabo Protocol. It was also provided in Article 46F of the Malabo Protocol that once this court can exercise jurisdiction if one or more of such crimes will refer to the prosecutor by either the state party, Assembly of Heads of State and Governments of the African Union, or the Peace and Security Council of the African Union. We humbly refer this honorable court to paragraph 11 of the Moot Pact, where this case was referred to the prosecutor by the Peace and Security Council as Resolution 3540/2020. We shall further argue this issue of jurisdiction on the grounds in which an international court can assume jurisdiction, the material jurisdiction, the temporal jurisdiction, and the territorial jurisdiction. In respect to the material jurisdiction, it was provided in the case of Musa County and other of the Republic of Mali that a court can assume material jurisdiction once the alleged violations are protected by either a protocol or any other human rights instrument. Your Excellency, in respect to this instant case, the alleged violations of Adugabolo are provided in Article 28D of the Malabo Protocol, Article 2 sub 1 paragraph B of the 1999 International Convention for the Suppression of the Financing of Terrorism, as well as the African Charter on Human and People's Rights. In regards to the temporal jurisdiction of this honorable court, in the Malabo Protocol, Article 46 provides that once this court can assume jurisdiction only in respect to crimes that were committed after the entry into force of this protocol. Also, in territorial jurisdiction, once the crimes are committed in the territory of the respondent state, court can assume jurisdiction. We only submit on the first aspect of our argument that as is the condition of jurisdiction has been provided for, has been met in this case. This court can assume jurisdiction. I will proceed to the second aspect, which is the admissibility of this case proper. Your Excellency, it is the concession of the prosecution that this case does not fall within the grounds of inadmissibility of a case, which was provided in Article 46H sub 2 of the Malabo Protocol. Our argument on the exception to the grounds of inadmissibility of a case, which was provided in Article 46I sub 2 of the Malabo Protocol. If the proceedings were done in a way to shield the criminal from
interrupt you. What's the difference between jurisdiction and admissibility?
Yes, I can't hear you.
What's the difference between jurisdiction and admissibility?
Most obliged, Your Excellencies, jurisdiction is the power of a court to hear a case, to make a decision that binds parties to a case properly brought before it. While admissibility is the legal appropriateness of a court power in relation to a case brought before it. Jurisdiction has to do with power of the court, while admissibility has to do with the claims brought before the court. Your Excellency, we rely on the exception to the principle of double jeopardy. In this case, as Adugabolo was tried in the wrong court, he was tried in the criminal court of Chatu in Chuma. However, the crimes were committed in the territory of Zengin. If at all the national court should have tried Adugabolo, it is the national court of Zengin, not the criminal court of Chatu in Chuma. Your Excellencies, we are relying on the authority of crimes committed in Sierra Leone while he was serving as the president in Nigeria, but was extradited back to Sierra Leone where he committed the alleged crime. This court called that the defendant should be charged and not where he was arrested, as in this instance case. Also, the duration of trial in which Adugabolo was tried in the criminal court of Chatu is too short for a crime as grave as war crime. The actual length of a proceedings can take place is not stated in any instrument. However, There are conditions, there are factors that must be considered in looking at the reasonable length of time a proceeding can take place, looking at the complexity of the case, the behavior of the accused, and the diligence of the authorities in prosecuting him. This was held in the case of the Inter-American Commission on Human Rights, Argentina's case 11.245, paragraph 111. Looking at the complexity of this case has to do with the rape and abduction of women from the locality of Funani, the killing of innocent children and 8 wounded soldiers when an hospital was attacked in Abaraj. Your Excellency, this case has to do with the shooting down of a defenseless civilian aircraft, which led to the death of over 200 passengers. We humbly submit that since the principle of double jeopardy does not bind this case is very much admissible before the African Court of Justice and Human Rights. In respect to the second issue, which has been distinct for determination in this case, it borders on the grounds to believe the existence of war crimes in the territory of Zengi from February 2018. It is necessary to establish the type of armed conflict that occurred in Zengi, which is an armed conflict of non-international armed character. And a non-international armed conflict consists of a protracted armed violence within a government authority, a government armed group, and a non-governmental armed group, or within non-governmental armed group within the same state. Your Excellency, it was provided in the prosecutor versus Dusko Tadic that the criteria that must be fulfilled for a non-international armed conflict to be established at level of intensity and organization. Looking at the death of hundreds of people that occurred in the territory of Zengi, it can be seen that the criteria of level of intensity has been fulfilled in this case. And looking at the fact that the CLA can be able to plan and carry out the attacks shows that they have responsible command structure within the armed group. Again, it was reported by Guinea, a global news agency, on the 13th of the same month. The attack on an hospital in Abaraj, which led to the death of 8 wounded soldiers and 10 children being taken care of. Your Excellencies, in considering yet not considered that even though the hospital was used as a secret annex, the principle of wounded soldiers should not be attacked. Rather, the de combat should not be attacked. Rather, they should be treated humanly. Also, soldiers should not be subject to attack at any point in time in war, no matter the circumstances. In the case of the prosecutor versus Dominic, the defendant was held guilty for attacking children, using them as child soldiers, and also sexually violating them. The only bring to notice of this honorable court the rape and abduction of women from the locality of Funani. Your Excellency, looking at this case, according to Article 28, this sub E, paragraph 6 of the Malabo Protocol, any form of sexual violence constitutes a grave breach of the Geneva Convention. The CLA has breached the Geneva Convention in this case. We all be to notice of this honorable court the shooting down of the defenseless civilian aircraft as of July 6, 2019, which is stated in paragraph 7 of the Moot Pact. Your Excellencies, based on this report of news agencies that has been filed before this honorable court and that has been corroborated by evidence of NGOs and the investigations carried out by international investigators and Zeginian prosecutions, we only submit that there are reasonable grounds beyond reasonable doubt that indeed war crimes occurred in the territory of Zengi from February 2018, and we pretty much vote in our favor.
Your time is up, but you have an extra minute that will also give the defense team to wrap up your arguments, please.
Much obliged, Your Excellencies. Your Excellencies, various convictions have been made on reports of news agencies and NGOs. Looking at the case of prosecutor versus Bemba, NGOs' reports can be admitted as evidence once they are probative value. Without the reports of these news agencies and NGOs, the situation in Zengi would nowhere have been ascertained. We only submit that there are reasonable grounds beyond reasonable doubt, flowing from this argument with the report of these news agencies, NGOs, as well as investigations that war crimes indeed occurred in the territory of Zengi from February 2018.
Thank you, Councillor. Is the defense team here?
Defense team, I think they are muted. You need to unmute yourself.
Can you hear us, Your Honor?
Yes. Yes, councillors. We
Okay.
can, but before you
All right.
start, I'd like to ask the favor to the clerk if she can show us when the time is elapsing, please, so we can all have in mind the time, please. Okay, so defense team, please proceed.
Can you hear us, Your Honor?
Yes, councillor, please proceed.
Okay. May it please the court, the President of African Court of Justice and Human Rights, and other presiding judges, may it please the court, Your Honors. My name is IM23D1, and I appear for the defendant in this matter. I would like to introduce my erudite and learned colleague, D2, and who also appears for the defendant in this matter. Our team will make 3 submissions. I will expound on the first two, that is on the inadmissibility of the case before ACJHR, and secondly, on the lack of reasonable grounds to believe that war crimes were committed in Zengin Mapalo. And the third one, our third submission, will be expounded on by my learned colleague, D2 Anyak, is on the lack of responsibility, superior responsibility of Adugabolo under Article 46B3. Unless I can be of assistance to Your Honors, allow me to proceed to my first submission. On the admissibility of the case before ACJAR, we as defense submit that the case is inadmissible before this court. I have divided this into two lines or limbs of argument. One, the first limb is the court has no temporal jurisdiction, Your Honors. Under Article 46E of Malabo Protocol, the court has only jurisdiction with respect to crimes committed after entry into force of this protocol and statute, and of which Malabo Protocol is not yet in force. So, Your Honor, this court has no jurisdiction, it has no temporal jurisdiction. And if you go to paragraph 1, just as evidence, lines 6, 7, and 8, it is very clear that all 3 states have ratified the protocol. That is Zengin, Chuma, and Pindu. They are the only states that have ratified the protocol, and yet the protocol has to be ratified by 15 states for it to come in force. So we are saying under Article 46E, this court has no jurisdiction whatsoever. Again, if I can give you a case, Your Honor, the case of Lubanga, it states that paragraph 781, it states that only court can have jurisdiction on matters which come in respect after the entry into force of that very protocol and statute. So that case very well supports our own argument. Our second limb of argument, Your Honors, is that even if the court has jurisdiction, this case is still inadmissible before this court, and I have divided it into arguments, 4 arguments.
Counselor,
the first argument.
Counselor, let me interrupt you. What's the difference between jurisdiction and admissibility?
Yes, Your Honor, much obliged, Your Honor. Jurisdiction is the competence of the court to try a case, while admissibility are the circumstances that warrant the trial of the case by the court. This is the difference, Your Honor, in precise terms. Thank you.
Has any international tribunal reached to the same conclusion that you do? Can you provide us with any case law in which jurisdiction and admissibility are defined as you just mentioned?
Yes, Your Honor. In the case of Uhuru Muigai Kenyatta, Your Honor, it has been an issue that the case was inadmissible before ICC based on the lack of sufficient evidence. And this was very well eloquated that there's a difference between jurisdiction, the court having jurisdiction, the ICC had jurisdiction, but the case of Uhuru was inadmissible before it in a sense that there was no sufficient evidence. So they distinguished in the case of Uhuru Muigai Kenyatta jurisdiction, which was defined as competent of the court to try a case, and in admissibility, which is in fact the circumstances of the case to warrant trial before a court. That is the case, Your Honor. May I proceed with the submission, Your Honor?
Yes, Counselor, please.
Yes. Thank you, Your Honor. Now, my second argument is that even if this court has jurisdiction, Your Honor, our own argument is that it's still inadmissible before this court, because our first argument is on the principle of non bis in idem. That is under Article 46I(1) of Malabo Protocol, which states that a case that has been tried before a national court cannot be tried again by the ACJHR, and that is very clear. So we are saying that under pursuant to paragraph 16 of the facts, it is very clearly stated that the Chuma Criminal Court tried Mr. Bolo and acquitted him of all the war crimes. So we are seeing no point of double jeopardy being invoked in this very situation. Our client has in fact been tried before and was acquitted, and he was very innocent. So that is on the principle of non bis in idem. And
Counselor,
then again,
let me interrupt you again, please. Are there any exceptions to the non bis in idem principle?
Yes, there are exceptions, Your Honor. The exceptions are very clear under the same 46HI2. The exceptions are that if the court is, if the state is unwilling and unable to try the case, and then in fact that would become an exception. And if there is also shielding of the victim, of which we are saying these exceptions do not apply here because our own client Aduga Bolo was not trying to be shielded in Kobole Court. Kobole was not Kobole but Chuma, due to the mending that has been made. Chuma Criminal Court did not shield Aduga Bolo in whatsoever way. If you look at it, you will find that prosecutor was invited by the Minister of Justice. That is by the Minister of Justice in Chuma. So there was no shielding that happened. So the exceptions here do not apply. May I proceed, Your Honor?
But, Counselor, what about impartiality? Do you consider that this National Criminal Court decision was impartial?
This, much obliged, Your Honor. The court in Chuma was very impartial, 100%, in the sense that Aduga Bolo was tried, but it was invoked that there was no sufficient evidence to prosecute the case, to in fact convict Aduga Bolo. So there was a lot of partiality in the case, Your Honor. There was a lot of impartiality, so there was fairness.
Counsel, just a follow-up question. Talking about the impartiality, don't you think, I just need you to make a comment on the 2 hours, 30 minutes that was given by the courts to hear the matter and peruse through the evidence. Do you think the 2 hours, 30 minutes is enough for the court to go through the evidence that was adduced by the prosecution?
Much obliged, Your Honor. Much obliged, Your Honor. There is no any law in the world which states the time in which the trial should be conducted. Even if it is 2 hours, even if it is 1 hour, and it was fair, it still stands before the court, because there is no law in the world which states that a duration of time in which a person was tried means that that very case was not tried partially or impartially, rather. May I proceed with Your Honor's permission? Yes, we are in fact, we in fact put them together with the principle of complementarity principle, in a sense that under Article 46H of Malabo Protocol 2, it is that a case is admissible before ACJHR where the person concerned has already been tried for the conduct which is a subject of complaint, and we are saying our client Aduga Bolo has already been tried. This is well projected in the case of Kantanga, in which it was held that once a person has been tried before a court, he or she can never be tried again, and this invokes clearly complementarity principle. Another point is that 46H2D of the complementarity jurisdiction.
Chancellor, let me interrupt you. What is complementarity? What is the principle of complementarity, and can you provide this court with any case law in which the principle of complementarity has been analyzed?
Yes, Your Honor. Complementarity principle states that the national courts are supplemented by the international courts. But in this, it is very clear the way in which we are using comparative jurisdiction here is that a case is inadmissible before an international court when the person in question has already been tried for the conduct in which the complaint has already been forwarded. That is it. And in the case of Katanga is very clear. The case of Katanga invokes complementarity principle in the sense that there is no person who has already been tried should be tried again. Much obliged, Your Honor.
Would you avail the court with a full citation of that case?
The case of Katanga, it states that if a person has been tried already,
The citation, which court exactly?
that was the International Criminal Court, ICC, Your Honor.
That's the full citation.
The citation is that once a case has been tried by any other court, it cannot stand before the International Criminal Court.
It's okay, you can proceed with your arguments.
Much obliged, Your Honor. Now, again, we will say that in our own submission, again, we are saying 46H2D says that if the case is not of sufficient gravity, and then the case, in fact, the case does not warrant to stand before this court. So this case is not admissible before this court because there is insufficient gravity to warrant further action by the court. And that is very clear, Your Honor. The threshold is stated in the case of Mavi Marma affair, whereby the threshold was very clear that there has to be qualitative and there has to be quantitative criteria. In 2010, instead, the Israelite forces, which killed all 9 passengers on board, and Marma reacted by blockading Gaza strips. So the assessment of the gravity was put in and was said that factors such as scale, nature, and manner of commission and impact had to be considered. So we are saying here, our own case here does not meet the threshold of gravity. So it has to be thrown out of this court, Your Honor, with much respect. And then, Your Honor, proceeding again, I would say that our second argument is on immunity. Immunity, Your Honor. That Aduga Bolo is a senior official of Zengin. Under paragraph 9, that is line 13, it states that Aduga was a special presidential advisor on defense to the president of Tuma. And so, as Article 46B of Malabo Protocol states very clearly, that any senior official who is on official duties bears functional immunity. So this case has no any means of trying someone who has functional immunity. And we're invoking that this court has no immunity at all.
But,
this was
Consular, there's been international criminal tribunal decisions, for example, in the Omar al-Bashir case, in which immunities of a senior official, senior official, have been lifted in order for him to be prosecuted by his crime. Don't you think that maybe because of the seriousness of what he's being charged with, shouldn't we lift his immunity so he can be judged?
Your Honor, there is no clear evidence that this very case, the allegations that I have up the reports, our own senior official, our own client committed them. There is no way that he committed them. It has not been shown anywhere, Your Honor. If I can give a case of the arrest warrant of Omar Hamad Hassan al-Bashir, it was created, it was clearly stated by the Jordanian lawyer who argued that Bashir was a head of state at the time he visited Jordan, and Jordan was not obliged to, in fact, arrest President Bashir because President Bashir bore immunity at that very time, Your Honor. May I proceed, Your Honor?
Yes, Consular, please.
Yes. Argument 3, the violation of rights. This court has no also immunity in a sense that Aduga Bolo's rights were violated. I will help you with a case, Your Honor, on Wen's case. On Wen's case, that is paragraph 44 on Wen's case before the ICC. It states very clear that where fair trial becomes impossible,
Counsel.
in terms to put the person on trial. Much obliged, Your Honor.
Let's hold on just a minute. You've argued human rights that Adugo Bolo's rights were violated, but the facts also reveal that many rights were violated: the right to life, right? So many rights, including rights of children, which are very, 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 they are handled with care. So how do you come to court where in fact, there's a maxim that says, "He who comes to equity must come with clean hands," and then you're arguing about your rights while knowing that your client had also violated other people's rights. So would your argument still stand? I'm just trying to understand your argument or the line in which you're arguing and what you expect of court.
Much obliged, Your Honor. The hospital was used as a secret annex, and under Rule 8 of the IHL principles of the International Humanitarian Law principles, Rule 8 says that military objects are only that are limited by their nature, by their use, by their location, and for their purpose must make an effective contribution to military action. And if these military objects are turned, these civilian objects rather are turned out to be civilian objects, that means there you are trying to see that your own court is in fact invoking something which is not happening. Yes, and they're saying as well, Rule 23, it says that, to answer you, Your Honor, it says that each part of conflict must, to the extent be feasible, avoid locating military objects within a densely populated area. The civilians have to be removed from a military base. And this goes to the Zanginian authorities. It is the Zanginian authorities that erred to put civilians in a military object and to turn a civilian object into a military object because it was a secret annex. And Rule 23 is an exception. Yes, Your Honor. May I proceed, Your Honor?
Counselor, a follow-up question.
Your Honor's permission.
But I believe in that, are you listening to me? Are you listening to me?
Yes, Your Honor.
My question
I'm listening to you, Your Honor. Much obliged.
is yes, if it's true that it was an annex, but however there were children in that place. There were 10 children. Don't you think that children have a special protection under international humanitarian law?
Your Honor, we are attributing the killing of the 8 wounded soldiers and 10 innocent children to the Guinean army, because the Guinean army was using that civilian object, the hospital in Abra, human shield, and this goes against Rule 10 of international humanitarian principles. It says clearly that once civilian objects have been turned out to be military objects and they are used as human shield, that means that person is liable. And we are saying very clearly that it is the Zanginian authorities that have in fact violated Rule 10 of international humanitarian law. And so this loss is attributed to them. They had turned the civilian object into a Rule 23. Your Honor, may I proceed? May I proceed, Your Honor?
Yes, Councillor, please.
Yes, succinctly, moving on to my second submission, I would like to in fact divide it into 4 parts. Number one, I would say that the attack of the hospital in Aberraj, which contained 8 wounded soldiers and 10 innocent children, was in fact used by the Kenyan army as a human shield, and this violates Rule 8 of the international humanitarian law principle. And I would say again, the attack on ICRC vehicles and materials, there is no sufficient evidence to corroborate this report. So under the case of, it says very clearly that the NGO reports cannot be relied on. The NGO reports which are not credible, which are not reliable, are in fact not admissible before the court. And for the abducted girls, Your Honor, they were taken to Chuma and justice was served under paragraph 9 and 17. And down of the ALV-22 aircraft were unfounded, and these activities are not related to CLA because there is no open air campaign that CLA is conducting here. There is no need of CLA killing the people who are not of Zengin origin and whatsoever. So, with much like Your Honor, I will take you to a case of Lubanga, that is paragraph 31, and Alexovic, that is in the case of International Criminal Tribunal for former Yugoslavia. That is paragraph 15, which says that all evidence that tends to incriminate a person is prejudicial to him, and the chamber must be careful not to ensure that it is not unfair to admit disputed material. For instance, a slide or mural provocative value, which has a capacity to prejudice fair assessment of the issue in this case. With your honor's permission, as my time as I like to welcome my
I lost them. Did you lose them as well?
Yes.
Let's stop the time. Defense 2 has 10 minutes.
I think they're back.
Your Honor, I hope you can hear me.
Yes. We can hear you.
I would like to continue my and control of those in game. The second link of my argument is going to be on the fact that by the atrocities were committed, Adugabolo was in a separate division as the forces of CLA. Your Honor, I would like to proceed with my first submission.
Proceed, please.
May I proceed, Your Honor?
Yes, Councillor, please proceed.
Adugabolo has no effective control over the forces in Zangin. Pursuant to Article 28 of yes, Adugabolo has no superior responsibility because he has no effective control of the forces. Pursuant to Article 28 of Roman Statute, it clearly states that for a superior responsibility to exist, a superior must have effective control over the subordinates and must have failed the actions that are taking place. Your Honor, if I may refer you to our facts, the facts in paragraph 4, it clearly states that on 13th of February, the attack is had already been appointed as of on the 10th of February 2018. That is according to paragraph 8, line 8, Your Honor. And when he was appointed, it is clearly stated in that paragraph of Your Honor, Adugabo had reluctantly and MLC denial respect to the case of Ilologic. Are you hearing me, Your Honor?
We can hear you, but you're cutting through.
Your Honor, said clearly that if that control exists at the time the crimes were committed. Your Honor, I'd like to clearly underscore here that there was no effective control. There was no effective control over the forces by the time these crimes were committed. And there would be no reason, Your Honor, for the prosecution not to believe that Aduga Bolo has absolutely no effective control over the forces in Zim. Your Honor, may I provide you another case, the case of prosecutor versus Delamish. In this case, in paragraph 370, it is clearly stated that being a commander is not enough to justify superior responsibility. Rather, there should be non-existence of, there should be existence of possession or non-possession of control, okay, over the actions of the subordinates. In this respect, Your Honor, our client has no possession, absolutely, has no possession of control over the activities of CA that are happening in Zangin, in Mapalo. Your Honor, yes, Your Honor.
Is there a difference between superior responsibility and command responsibility? Maybe you could guide the court on what exactly you're arguing. Is it under superior responsibility or command responsibility?
Much obliged, Your Honor. There is a clear difference, and I would like to refer you, Your Honor, to Article 28 of Roman Statute. Article 28A clearly states that command responsibility is their responsibility by military commanders. And Article 28B of Roman Statutes also asserts other responsibilities that could be by any superior that is not a military commander. In this respect, superior responsibility in this respect could be of a person that has influence and not a military commander. And command responsibility is restricted to military commander, Your Honor. May I proceed, Your Honor?
Yes,
may I proceed, Your Honor? Yes, I'm going to proceed to the second limb of my argument. The second limb of my argument is that by the time these atrocities are later being committed, Aduga Bolo was in Chuma. He was in Chuma and the forces were in Zangin. And he had taken up a bigger position of Ministry of Defense. Your Honor, paragraph 9 clearly states that Aduga Bolo was monopolized by his duties of the Ministry of Defense in Chuma. I would like to translate or interpret the word monopolized in my own understanding to mean that he was completely consumed by the activities of the Ministry of Defense and that he had no time to know what was happening in Zangin. And because he was completely in jurisdiction, Your Honor, Aduga Bolo had no possibility to exert necessary measures to endeavor that he controls the activities of CLA while he was in a separate jurisdiction, while the forces of CLA were in a separate jurisdiction. I would like to use Bemba case in this respect. Your Honor, the reason Bemba was acquitted in 2018 is because the test of whether he had the ability and the capacity to prevent his forces from committing those atrocities in Central African Republic, it was stated that because he was in a separate jurisdiction, there was no possibility for Bemba to control his forces. Your Honor, I'd like to also relate this to our case. Our had no possibility because he was in a separate jurisdiction in Chuma. And I would like the prosecution to believe that Aduga Bolo did not know the activities that were happening in Zangin, and he had no possibility to control those activities Aduga Bolo had absolutely no effective control over the forces in Zengin. And for that matter, Aduga Bolo is a free man. He's a man with clean hands in this matter. Your Honor, this court...
Counselor, let me interrupt you. But throughout the case, there are proofs that he did know what the acts that the group was making. So he did have knowledge about that. It's just
Your
knowledge.
Honor,
Yes, please proceed.
much obliged, Your Honor, much obliged. The reports that he knew came from from Nika. And we know in this case, Your Honor, Ganika has always reported those matters that will favor Zenginian government. And in this respect, we are saying these are fabricated lies. They have no basis. Aduga Bolo took a very big position in Chuma. And on paragraph 8, Your Honor, paragraph 8 of the facts, line 8, clearly states that Aduga Bolo reluctantly abandoned CLA and MLC respectively. He abandoned the duties to Taribo and Kafila Dineo respectively. And as a result, Your Honor, I would like to submit that this case should not proceed to trial. The confirmation in this respect should be dismissed because Aduga Bolo is a free man. He has clean hands and he did not want to commit atrocity. Otherwise, Your Honor, he would have done them on the 10th or even before the 10th when he was appointed. These atrocities happened on the 13th after he has already left and he had gone to Chuma. Your Honor, these are our submission that Aduga Bolo is with clean hands and this case should not proceed to trial and that it should be dismissed, Your Honor.
Thank you,
Sorry,
Councillor.
Maybe just before you go, paragraph 9.
Yes.
Paragraph 9 of the compromise is stating that Aduga Bolo had regular contacts with his childhood friends and fighters there, meaning in Zengin. So how would you make submissions that he had no knowledge or he had no reason to know of the happenings in Zengin? And yet paragraph 9 is confirming that he had regular contacts. So what would be
Your Honor, Your Honor, I would like to submit that Aduga Bolo may have contacted people in Zengin. Mere fact that he's a commander or the mere fact that he has influence on some people in Zengin does not justify that he had effective control, Your Honor. And I would like to justify this statement by use of the case of Delalish, in which it is clearly stated that being a commander is not enough, and being a formal officer or commander of forces is not enough to justify that you will have superior responsibility unless there is effective authority and control, Your Honor, of which our client Aduga Bolo did not have effective authority and control over the forces in Zengin.
Thank you,
But you are conceding that Aduga Bolo is the commander for the CAO. Are you conceding?
Your Honor, it is mentioned at the beginning that Aduga Bolo helped to form CLA. But it is very clear, and I would like the prosecution to believe that Aduga Bolo is a man with clean hands. He did not want to start war, otherwise he would have started before he left to Chuma on the 9th or on the 8th or even before the 10th of February. On the 10th of February, he abandoned all powers to Taribo and Kafila Dineo, respectively, Your Honor. And Aduga Bolo, by the time he was in Chuma, there was no superior subordinate relationship still existing, Your Honor. And I would like to also substantiate this with the case of Holy Lovich, which said that superior responsibility will only exist if there is effective control by the time those atrocities are committed, of which by the time these atrocities are alleged to have been committed on the 13th of February, Your Honor, Aduga Bolo had already assumed a bigger position in Chuma, and he had already abandoned his duties to Tarib, his brother, and Kafilo Dinayo. And I would like to assert that, Your Honor, that Aduga Bolo has clean hands. He had no effective control, Your Honor, and Aduga Bolo was in a separate jurisdiction of which he had no ability and no means to prevent the atrocities. And that is supported by the case of Bemba, Your Honor.
Thank you, Counselor.
Yes, Your Honor.
We now proceed with the rebuttal from the prosecution.
Most grateful, Your Excellency. Your Excellency, in the course of the argument of the defense, it has been noted that they argue that the Malabo Protocol has not been ratified. It is the strong contention of the prosecution that this is only a figment of their imagination. The Moot fact has stated that 3 African countries have ratified this. It does not state that in all the African countries, these are only the 3 that have been ratified. Further, there is no sufficient evidence to adduce before this honorable court that indeed only these 3 in the whole of Africa has been ratified. The Moot fact does not deal substantially on the issue of ratification. This is only a figment of their imagination. Further, Your Excellency, they invoked the principle of non-bis in idem. First, it is important to restate that the principle of non-bis in idem cannot be invoked based on the fact that there was a mistrial. It should have been tried in the court of Zengin, but was tried in Chuma, which is in opposition of the ruling of the court in Prosecutor versus Charles Taylor. It should be tried where the crimes have been taking place, assuming without conceding that that indeed there was not a mistrial, but there was a mistrial. The 2.5 trial in this instance fall under the exception that are stated in paragraph A of this provision. Your Excellency, the 2.5 trial is not enough. In the case of Inter-America Commission of Human Rights versus Argentina, it was ruled that taking into consideration of the factors such as the complexity of the case, it was ruled that the case should have been given much time to determine the indictment placed on the defendant. Your Excellencies, there wasn't enough time to do this. Admittedly, Your Excellencies, there is no particular law that says the duration of time. However, premised on the gravity of this particular case, it is important that the time put there falls under the exception of paragraph A of the principle of non-bis in idem. Further, Your Excellency, they invoke the principle of complementarity. The complementarity principle states that if he had been tried by that the national court of member states is also in complementary jurisdiction of this honorable court. It is the position of the prosecution that the national magistrate court is not a national court as stipulated in this provision. The national court in this instance has ruled in the case of Johnson versus Ghana, where the court returned the case based on the fact that it had not yet reached the national apex court. In this case, before the prosecution can invoke the principle of complementarity, it has to have gotten to the apex court, and in this instance, it has only reached the magistrate court. Your Excellencies, in the case of in the Nigerian court, in the case of Josiah versus State, the learned Justice Okuta recalled that justice is a three-way thing. Justice for the accused, justice for the society that their norms and values have been desecrated, and justice for the victim. Further, Your Excellencies, it was recorded that they relied on invoking the immunity. It's important to state that the immunity as stated in the Malabo Protocol only falls for senior state counsel. Your Excellency, senior state counsels are persons that act and serve directly for the state. Adugabolo in this instance was degraded to a senior special advisor that serves the president and not the state. First, he cannot invoke the immunity in this case. Further, it was held that even as a cardinal and important principle of international law, in the case of prosecutor versus Gaddafi, it is important that immunity is disregarded with. Further, they argued that their rights were violated. it is the position of counsel that if their rights were violated, this is not the substantial reason of this particular case. They should proceed to court if they feel that their rights have been violated. Further, they noted that the military of the attack on the building was premised on the military objective. Your Excellency, it's important to consider the principle of force they combat, which is also corroborated by Article 7 or Article 7 sub 2 of the additional protocol to the Geneva Convention that deals with armed conflict of non-international character. It states that where soldiers are injured, they deserve humane treatment. Now they went in there, they did not only disregard this principle, but they equally killed children. Your Excellencies, the military objective as a defense for the attack cannot be justified. Further on issue 3, they stated that that Adigabolo had no possession or control. It is stated that in Article 12 of the Two Liberation Movement, he had the powers over the military operations of the Two Liberation Army. In fact, he had no control, but he gave order while he was still in Zengin, and the order was executed in Chuma. There were others stated that he was monopolized by his duties, but he was monopolized and busy by his duties, but he sought for funds in the promotion of the nefarious activities of Two Liberation Army. They equally tried invoking the ruling of the court in Bemba's case.
Counselor, your time's up, but you have extra 30 seconds that would also give the defense team. So please wrap up your
Most grateful, Your Excellency. It invokes the principle of the ruling of the court in Bemba's case, which says that he had no means. He had no means to control this. He had no effective control, but he gave an order in Chuma, and the order was executed. Your Excellencies, the principles for effective control have been enumerated in the case of Prosecutor versus Delany, which says that if he has powers, and the order he gave was executed, which have been clearly established. Further, Your Excellencies, it is contended that based on this rebuttal and the arguments previously canvassed, that this court confirms charges on the defendants and will proceed to trial. Most grateful, Your Excellency.
Thank you, Counselor. The defense team can proceed with their short rebuttal, please.
Conflict. Rather, Your Honor, may I proceed? Are you hearing me?
Yes, we're listening to you. Please proceed.
Yes, Your Honor, I would like to clearly underscore that this armed conflict has been wrongly characterized by the prosecution as international armed conflict. I hope I heard them well. And if that is the case, our characterization of this armed conflict is non-international armed conflict, Your Honor. And this is backed by Common Articles 3 of Geneva Conventions and also Malabo Protocol, Your Honor. Your Honor, I would also like to state that when it is mentioned that there was attack in a barrage hospital and children and wounded soldiers were killed, this is because Zengin Army had used the hospital as a secret annex for them to plan their attacks. And the Rule 10 of the norms in IHL, Your Honor, states that if a civilian object has been used to gain military advantage, it will lose the protection and it will become military objective. In this respect, we are clearly stating that, Your Honor, this hospital was being used as a military objective for the Zenginian army to gain military advantage. And in that respect, in fact, it's the Zenginian army that have been using the children and wounded soldiers as human shields, which is also against the rules of IHL, Your Honor. Your Honor, I would like to proceed to the issue of abducted girls. There is nowhere it is stated that these girls, it's stated, yes, the girls were abducted, but you may also see that in Chuma, when the girls were taken by Kafila Dinayo took the girls to Chuma, and when they went there, he was disciplined, Your Honor, he was disciplined by Aduga Bolo, and the reason he disciplined him, I still refer to Bemba case, is because they were in the same jurisdiction. By the time he went to Chuma with the girl, he was disciplined and the girls were released. Obviously, Your Honor, this case, the perpetrator, Phila Dineo, who took the girls to Chuma, has already been punished for that matter, and the girls have been released, and justice has been served. Your Honor, I would like to continue to highlight clearly a few things. There is no highlight anywhere that, Your Honor, I would like to continue to clearly state on non-bis in idem. Non-bis in idem is a principle that clearly states that if a case has been tried, it cannot be tried again on the same conduct and for the same parties. Your Honor, there is no way the Chuma court would have shielded Aduga Bolo when they lifted his immunity and they invited the Minister of Justice of Zengin, and the Minister of Justice confided in the justice system of Chuma, and he warrant the process to continue. Your Honor, the process in Chuma was impartial, and there was no shilling, and this principle of non-bis in idem clearly applies. Your Honor, there is a case of Nasser or Rich, which states clearly in paragraph 16 that if a case has already been tried, there would be absolutely no reason to bring the same case again before any competent court. Your Honor, the issue of immunity that the prosecution has invoked, of course, there is immunity for Aduga Bolo, and it is not stated anywhere in the facts that that immunity was lifted before he was arrested. He was in Pindu in his official capacity, Your Honor, and as he was in his official capacity, that immunity applies. That immunity applies, Your Honor, and that is relevant to the Omar Hassan al-Bashir. In the case of Omar Hassan al-Bashir, Jordanian agencies, they declined to arrest him because he was the head of the state and he had immunity. We would like to clearly underscore, Your Honor, that Aduga Bolo, our client, has clean hands. He had no superior responsibility over the cases, over the forces in Zengin. He absolutely had no superior responsibility, and that this case should not continue to trial. It should be dismissed because Aduga Bolo had no superior responsibility, and there were no evidence to corroborate the hearsays and those reports by Ganikas and other reporting agencies, which has no, these reports have no basis and they have no ground to corroborate them. And Your Honor, for that matter, we would like to assert Bemba case, where it clearly stated that because Bemba was in another position and he was unable to control the atrocities, he was acquitted, Your Honor. We are asking that this case should not proceed to trial. It should, Aduga should go with clean hands. Thank you. Those are our submissions.
Thank you, Councillor. Then we'll go to the judges' room, deliberate. Please stay here so we can then go back and give you feedback.
Thank you. Thank you, Your Honor.
Clerk, I think you're muted. Okay, so we'll go to the judge room.
Yes, you can proceed to the judge's room.